Welcome to the US UK Tax Talk podcast. Today we're going to do something a little bit different. If you haven't noticed, we're not joined today by a guest in the studio. That's because I'm going to take the opportunity to talk to you by myself. That's right, just in case you thought the thing this podcast needs is more of Aidan Grant talking. We're going to take the chance to answer some listener Q&As, some questions that have been fed into us that you feel haven't been touched yet on this podcast, and I want to devote an episode to addressing some of them. Now, I'm sure you clever listeners know this already, but I'm going to talk in generic terms about the US-UK tax and estate planning world. Equally, if you have any topics that I didn't cover today that you'd like to be covered on a future episode, then make sure to contact us using the details in the show notes to this episode, and we'd love to hear from you. We hope you enjoy the episode. So, on to the first question, which reads as follows. Does my estate planning need to be complicated just because I'm an American living in the UK? Now, this is a really common question I get asked by a lot of clients right at the beginning of a discussion. They want to talk about their will planning, they want to talk about their estate planning, but they have a concern. They've read somewhere, maybe they've listened to this podcast, and they've thought, necessarily, there's a minimum level of complexity that has to arise when it comes to thinking about their estate planning. I like to try and dispel that myth relatively early on by saying that there is no reason per se, no reason in and of itself, why an estate plan has to be complicated just because it intersects with two different tax jurisdictions. The US and the UK have a lot of rules that are similar, and I accept some rules are different, or at the very least, the way in which they are enacted in practice can be quite different. But at its fundamental heart, estate planning in the US and the UK aims to achieve similar goals, and the ways in which you can achieve them are broadly aligned with each other. And so what I start by saying to a lot of clients is, if you have traditional, simple nuclear goals, let's say you are a married person, you and your spouse are doing your estate planning together, maybe one of you is an American, maybe both of you are Americans, you've got some children, be they minor children, adult children, maybe they're Americans, maybe they're not Americans. If you are looking to carry out what I said, traditional, simple estate planning, then your planning doesn't have to be more complicated just because you're an American. If, for example, you want to leave your wealth to a surviving spouse without any ongoing trusts, you're just looking to leave everything to your spouse when you pass away, and at your spouse's later death, the assets will be passed down to their children, then that is perfectly efficient in the US and the UK at a general level. Now, of course, we can make that planning more complicated. We can introduce trusts or other mechanisms into the estate plan to ring-fence assets to provide a degree of asset protection, whether during the surviving spouse's later lifetime, maybe on the chance of a remarriage, maybe for the children because they're going to be too young to inherit at an early age if the parents die prematurely. Maybe we want to introduce a degree of complexity for tax efficiency reasons, and there's lots of ways in which we can do that. But at its heart, if what you are seeking is simplicity, there is a way of cutting through that in an estate plan. What I say to clients is, let's start with the most simple estate plan we can think of, and I will build up from there in complexity, explaining along the way why it is that you've benefited from that increased complexity, rather than seeking to sell someone a more sophisticated plan that maybe they didn't need, and they didn't know that a simpler plan was available. If we are thinking about trusts, then we do need to think carefully about the tax considerations in both the US and the UK, because there can be instances of double taxation or a mismatch in the way in which the tax arises in both countries, and those have to be thought about carefully. For example, if we're leaving wealth to a surviving spouse on a form of trust, what I in the UK might refer to as a life interest trust, but an American practitioner might refer to as a Q-tip if the surviving spouse is an American, or a Q-dot if the surviving spouse is not an American, then whether the spouse is treated as owning the assets for estate tax in the US, inheritance tax in the UK, whether the spouse pays income tax on the trust income, or whether the trustees pay tax on the income, what happens if payments are made to other beneficiaries during the surviving spouse's lifetime, can we accelerate the spouse's interest, capitalize it and pass money down? These are all questions that are quite complicated and need to be thought through carefully. And so I do not want to diminish how complicated estate planning can get, but it's for you as an individual to decide how complicated you want your estate plan to be, and it's for us as advisors to explain to you what the merits and pitfalls of doing so are. So I hope that answers that reader's question. Our next question reads as follows. I'm an American living in the UK. Do I have to have a will in both countries? This is a really, really common question, which I think a lot of people assume the answer is yes. And the answer, in fact, is maybe. It's the traditional lawyer's refrain. So if you are living in the UK and you have assets in both countries, then the factor that's going to determine whether you want to have one will or multiple wills is going to really be a question of how you balance the competing factors of what has to happen at your death: complexity, cost, inconvenience to the family, tax efficiency, and so on. There is no hard and fast rule. The way I tend to describe it to people is think about what the point of a will is. The point of a will is to describe to the world, these are the people who are responsible for looking after my wealth, my executors, we would usually call them. And these are the people who are benefiting from my estate, the beneficiaries. They might be the same people, they might be different people. Now put yourself in the shoes of a custodian, like a bank, who's been approached by someone to say, I act on behalf of this estate, I am an executor, I want access to these assets. How do you as the custodian know that the person who's confronting you or approached you is validly appointed as the person that they say they are? You'd like there to be some sort of regulated process to determine that this person is in fact the right person, and you can rely on that process. That process is what we refer to as the probate process. In the US and the UK, when someone dies, you submit their will to the courts. That probate process results in what is usually referred to as a grant of probate. And a grant of probate is the document that tells everyone this person or these people are the executors, and we, the courts, have adjudicated that the will in question is the last will and a valid will, and therefore you can rely on this document to deal with this person on a normal basis. Now, that's fine in the UK. If we have a UK will, we submit a UK will to the UK courts, you get a UK grant of probate, and you can approach a UK bank. That's all quite straightforward. However, if we have US assets and we take that same UK will and we try and take it to a grant of probate in the UK, and we then try and take the grant of probate to the US, many US custodians are going to look at that UK grant of probate and say, we don't recognize this document. We don't know what this document is. We're used to dealing with US grants of probate. And so what you have to do is, broadly speaking, reprobate the estate, reprobate the UK will in the US to result in a US grant of probate. That's an administrative process. It depends on the sort of size of the estate. It depends on the parties involved as to how complicated that is, but it is nevertheless an increased amount of time and, in practice, cost to have to go through the probate process at a second time after you've already gone through the probate process in the UK. The same is true in the US. If you have a US will but UK assets, you will end up needing to reprobate the US will in the UK. Compare and contrast that with having a will in both countries. You can, in essence, run both processes at the same time. It means you can start the US process and the UK process shortly after death, and you're running both processes concurrently rather than consecutively. That is fundamentally the main benefit of having two different wills. Of course, the downside is you have the upfront cost of two wills, and you've got to keep two wills updated, and the way in which they relate to each other has to be kept updated as well. So if you inadvertently write a will and then write a second will in the future, you could accidentally revoke the first will. So you need to be very careful about making sure that the two wills talk to each other properly. The other reason why it's often good to have a UK will alongside a US will, or speaking more specifically to a broader US estate plan, is that sometimes the whole point of a US estate plan is to avoid probate in the first place. So, for example, if you have a traditional US estate plan setup where maybe you have a US revocable living trust, that trust's purpose is to avoid probate and to not have to submit the will to the courts for probate. It speeds the process up. If, though, you have UK assets, and if those assets are not in the living trust, and so they have to be probated, and please don't take this as a reason to put UK assets in a living trust, that is a much more difficult discussion, which I'm not proposing to cover right now, then you're going to have to get a grant of probate in the UK anyway. And if you've only got a US will, maybe a US pour of a will that couples with the living trust, you're going to have to probate that will in the UK, which somewhat undermines the premise of the US estate plan of not needing probate in the first place. And so sometimes it might be that you could otherwise get away very comfortably with having a US will reprobated in the UK, except that the whole family's dynamic and the legal advice that was taken at the time on the creation of the estate plan was geared towards not having to do that. So you might be saving the family in the US a lot of bother and time and effort if we just isolate the UK assets under a will in the UK. The final point to make on this topic, on this question, is how do we define how the two wills interact with each other? And this is a topic that should be very familiar to a lawyer that deals with international clients. And so this isn't something for the client themselves to be concerned with, but it's good to know roughly how it works anyway. So in practice, what happens is you have a global will that is the kind of the lead will. That will be expressed to deal with the worldwide estate, except for assets in a certain jurisdiction or a couple of jurisdictions, depending on the complexity. So let's assume, for example, someone in the UK has a majority of their estate in the UK. I might draft them a will in the UK that covers their worldwide assets, except for the United States of America. They would then have a second will, the sort of the secondary will, that covers only assets in the US. So one is kind of a cookie cutter inverse of the other. So in the UK, worldwide will, less the US. In the US, only the US. And if it's done properly, that should mean that neither will revoke each other's if it's redone in the future. Neither will interrupts each other's probate process. That's the way it's supposed to work in practice, but that is also why it's so important to make sure that you have advisors in both countries that are familiar with dealing with cross-border matters, so we don't end up with one will that breaks that process and breaks that interaction between each other. So thank you so much for that question. Our next question reads as follows. I'm a UK resident and a US attorney is recommending that I put in place a living trust over my US assets to avoid probate. Should I do that? Or are there better ways to do that given my UK status? This is a question I get asked very frequently by people in the UK, either because they are about to embark upon a US estate planning exercise, or sometimes they've completed their US estate planning exercise and they've now come to me to solve the UK part. In a previous question, I addressed the interaction between US and UK estate plans, and part of the reason that works is because we're doing both plans at the same time, i.e. each advisor knows what the other is doing. Where you carry out your plans consecutively, there is a risk that what was done in the US may not work for UK purposes, or vice versa. And so in this scenario, I'm going to hope and assume the reader is thinking about doing this rather than it's something that actually happened a while ago and they're just looking for me to give them the thumbs up. The problem with living trusts from a UK perspective is something that we have addressed a number of times on this podcast, and I would encourage people to go back and listen to my episodes with Gillian Everall of Everfair Tax and understand more about living trusts and the potential problems they can give rise to at a general level. However, I want to address the question and address the issue specific to the question for the purposes here. The reason why I am hesitant to recommend a living trust is because of the uncertain UK tax treatment of living trusts. There is no guarantee that the way in which the UK government, HMRC, the tax authority, is going to deal with that trust from a UK perspective. There's no way to guarantee that that's going to be the same as in the US. And so we have the risk of unexpected UK taxation at the expense of, or rather in pursuit of, US probate avoidance. Now, that US probate avoidance may be significant in the US. That might be of real value, particularly if we are talking about US assets in a state where probate is particularly unattractive. However, we should not and we must not discount the very, very real potential UK tax consequences of pursuing that US probate avoidance, particularly if there aren't other ways that we can avoid those US probate consequences, which I'm going to allude to later. One of the main reasons why I am so often hesitant to recommend the use of living trusts for UK residents themselves is because of what can sometimes happen for inheritance tax purposes once the grantor or the grantors have died. If we hold assets during our lifetimes in a living trust, that can sometimes interrupt the availability of the inheritance tax spouse exemption on the first spouse's death, looking to leave assets to the surviving spouse. Whereas as a fundamental tenet of UK law, it is usually quite straightforward as a matter of estate planning in a domestic UK context for one spouse to leave their wealth to the surviving spouse at their death and for the first spouse's estate to benefit from inheritance tax. That is fairly straightforward. That is a very, very fundamental feature of UK estate planning, as I'm aware it is in the US. The problem is that estate planning presupposes that the way in which the wealth is passing from spouse one to spouse two is via a will in sort of death estate planning terms. The problem is if assets are held through a revocable living trust rather than in the grantor's own name, and thus the mechanism by which the surviving spouse inherits is not via the will, but is instead via the mechanism of the living trust, then this can sometimes cause ruptures in the availability of the spouse exemption. Specifically, the UK may not recognise the interest that the surviving spouse has in the living trust assets as a qualifying trust for the purposes of inheritance tax. And so the recommendation that I have is one of a number of alternatives. If we are looking to avoid US probate, and we are content that it is worth spending time and effort to avoid probate when, speaking frankly, you might not be there to be worried about the probate process, there are a few different options. Firstly, jointly held assets, but certainly as a matter of UK law and as I believe as a matter of US law, pass outright to the surviving owner without the need for probate. So you could think about holding joint assets. That can be particularly useful in the spousal context because you're then still benefiting from the tax reliefs on wealth left to a surviving spouse in both countries. If it's not a spouse you're leaving money to, then we also need to be careful about people putting joint assets in the name of, say, for example, the parent and the child, because that can give rise to wider tax consequences during the parent's lifetime, because they may be deemed to make a gift to the child, and we don't want to do that inadvertently. The second way that I'm familiar you can avoid probate in the US is through a process known as a transfer on death arrangement or a beneficiary designation. It's a strange feature of US sort of financial practice that we don't seem to have in the UK, where you can designate someone as the beneficiary of an account with a particular US custodian as being the beneficiary after your death. So pick your favorite national US bank. You can go to the bank and say, at my death, this is the person who inherits my account. In a UK context, it's not dissimilar in concept to a nomination of wishes over a pension, but I've always understood the main difference being that in the US, a transfer on death arrangement is binding, whereas a nomination of wishes over a UK pension is not binding in 99% of circumstances. That transfer on death arrangement in the US means the asset simply passes, or the funds in the account simply pass outright to the survivor beneficiary without the need for probate. So if what we have in the US are largely financial accounts, it could be that we could look to a combination of a UK will for the UK assets and transfer on death arrangements for the fundamental and significant US wealth. If we still had to go through probate to clean up a couple of these smaller items, then that's something that could be considered. But so long as we've got access to the main accounts in the US, that might be sufficient for some families so that the next generation are not met with a liquidity problem where they don't get access to funds they might well need to settle debts, pay tax, etc. All of which is to say, I want to reiterate the point I made previously, that the best estate planning on a global level, where we have assets in both countries or a taxpayer who is exposed to tax in both countries, is to conduct all of the global estate planning at the same time rather than trying to do it sequentially. That just gives you the best chance of ending in a scenario where you have peace of mind it's been done correctly and no lawyer has to go back and try and undo another lawyer's work. So thank you so much for that question. The next question reads, I feel like my estate planning wishes are simple, but as an American, I'm worried about my exposure to inheritance tax. Is there anything I can do? Now, this is a huge topic, and it is definitely something I cannot cover in its entirety in this Q&A session. There are a lot of inheritance tax planning options available for lots of people in the UK, whether or not they're an American, and lots of those topics are going to be the same for Americans as they are for non-Americans. What I'm going to try to do is touch on a few topics that might be a little bit more relevant to Americans and think about some of the ways that we can carry out those common planning techniques. A reminder for anyone who doesn't know how inheritance tax works, it is a little different in application to estate tax, and so it's important to know the difference. Estate tax and inheritance tax are both estate taxes in concept, by which I mean they are taxes on the estate of the individual when they die, rather than a tax on the receipt of the inheritance by the recipient. So, speaking frankly, the UK is incorrect to call it an inheritance tax when it's in fact a form of estate tax. That's important because what that means is it's the identity of the decedent, the person who's died, the person doing the planning. Their status is the one that's relevant for the purposes of ascertaining when tax is due, not the recipient. So if you are in the UK and you are thinking about the consequences of inheritance tax at your death, then we're thinking about your circumstances, just like how in the US we'd be thinking about your potential exposure to US estate tax. Conversely, and I suspect we might come onto this topic later, if there is someone in the US thinking about their estate planning, then they have a smaller nexus to the UK. They may have no nexus to the UK at all, and consequently inheritance tax on their death may well be significantly diminished relative to the same American living in the UK. The way in which inheritance tax starts to depart from estate tax is in the way in which lifetime gifts are calculated. So for the purposes of calculating someone's estate for inheritance tax purposes, we take the value of their estate at death, and we also bring back into account any gift, or most gifts, I should say, in the 7 years prior to death. We refer to lifetime gifts as potentially exempt transfers, or pets, you will sometimes hear a UK lawyer referring to them as, and if they are in the 7 years prior to death, they are failed pets. Those failed pets in the 7 years prior to death, added to the death estate, are what is chargeable to inheritance tax. And that is why you will often hear people in the UK talking about a 7-year rule for giving away assets, because if you give away assets and survive by 7 years and you don't retain any benefit in the assets, you've successfully given away those assets during your lifetime. Now, in a US-UK context, the distinction between the accumulation of wealth at death and those failed pets in the UK comes most acutely when we think about the allowances that are available in both countries. Both countries tax at the same rate. Estate tax and inheritance tax, I believe, is the same. It's currently 40%. The difference is the threshold over which that tax is paid. In the US, as many listeners may be aware, as of the 1st of January 2026, the Unified Credit Allowance, which is an American's aggregate lifetime gift and estate tax allowance, is currently $15 million per American. So for an American couple where both parties are American citizens, that's $30 million of wealth that can be left to the next generation. By comparison, the largest amount of money by default you can leave to the next generation in the UK is £325,000. That can sometimes be uplifted to £500,000 in certain circumstances, and the UK has a few other allowances available for certain qualifying assets like shares in certain trading companies, agricultural property, and so on. But fundamentally speaking, even if we act generously for a high net worth couple in the UK, we're still looking at never more than £1 million of total combined relief between both spouses. So £1 million in the UK versus $30 million in the US. It's a big, big difference. And so this is why it matters for Americans in the UK, because you can be someone as a couple, as an American couple, worth up to £30 million, and you thought you'd never have to worry about US estate tax. And then someone comes to the UK and they ask me about inheritance tax, and I have to say to them, it's not quite so straightforward because we've suddenly exposed you to tax at a much lower threshold. That's not necessarily a terrible thing because the inheritance tax doesn't kick in immediately. Since the 6th of April 2025, the UK has levied inheritance tax on a residency basis, and where someone has not been living in the UK for at least 10 of the previous 20 tax years, they are only broadly exposed to inheritance tax on their UK situs assets. So if someone is coming to the UK and they want to limit their exposure to inheritance tax, maybe they've got a large amount of US wealth, if they leave that wealth outside of the UK, they leave it in the US, they leave it in a US deposit account, they leave it in shares in a US company, etc., then it is shielded from UK inheritance tax. Once someone's been living in the UK for at least 10 of the previous 20 years, we refer to those people as long-term residents. You'll sometimes see that shortened to LTRs. And an LTR is exposed to inheritance tax on a worldwide basis. And that's the point at which a lot of Americans need to start thinking very, very acutely about their estate planning, because now inheritance tax is going to arise to all of their wealth. I promised that I would mention a couple of things that can be relevant for Americans in the UK thinking about their exposure to UK inheritance tax. Firstly, I mentioned those LTR rules previously. Of course, if an American is going to leave the UK, that is going to limit their exposure to inheritance tax on their non-UK assets at some point, depending on when they leave and how long they've been in the UK before they leave. But at a point, most fundamentally, you can avoid that exposure to inheritance tax on non-UK wealth if you leave the UK. That will be relevant for some people. There are other people who are very comfortable and happy to live in the UK and don't want to let the tax tail wag the dog, so the expression goes. Common estate planning tools in the UK would include lifetime gifts. So I mentioned the 7-year rule for pets. Passing wealth down to the next generation is a very common UK planning tool to limit the exposure to inheritance tax at death. The taxpayer would have to think carefully about their US gift tax rules. $19,000 a year per person, generally speaking, for example. But if that person has a healthy amount of their unified credit allowance left, they may be prepared to use up some of that $15 million allowance in pursuit of lowering the size of their estate for inheritance tax purposes, provided they are content that once they've lost some of that unified credit allowance, there is no guarantee they're going to get it back. So lifetime gifts can still form a common part of the estate plan. Maybe we want to take out some life insurance. Life insurance can be a very popular way of realizing funds at death to pay for inheritance tax that arises, and you are in effect prepaying the amount of tax that you need by giving up your income during your lifetime paying those premiums. That policy should be properly put into trust, and if you're an American, it probably needs to be a qualifying trust for US purposes. But that's a common way of making sure that funds are available if there's no other way of actually avoiding the amount of tax that falls due. And there are others, but those are some of the main things I wanted to talk about. Everyone's circumstances are different. Everyone should think about coupling tax planning with their estate planning. Make sure that they have a will, if they are married, that at the very least defers tax until the surviving spouse's death. And then on top of that, we can layer estate planning during their lifetimes to bring down the rate of inheritance tax further. But I would encourage everyone to seek a holistic estate planning review, and the will planning and the lifetime planning can then be taken together, and we can produce one overarching plan that should probably address all of their goals. So, our next question reads, my parents live in the US and they want to make gifts to me as part of their estate planning. Are there any UK tax issues I need to be aware of? This is one of the topics where there is the chance for some really significant UK tax savings, or if the planning is enacted in a way where UK tax wasn't thought about beforehand, there can actually be some really quite nasty UK tax pitfalls. So it can swing both ways in terms of the tax efficiency. I'm going to assume that the parents have no nexus personally to the UK. They weren't previously UK residents. They haven't got any UK assets. They are sort of wholly American people for these purposes. And I'm going to assume that the questioner lives in the UK and has lived in the UK for quite a while. Fundamentally speaking, if a parent wants to make a gift to someone in the UK, that gift is made without UK tax consequences as a general rule. So a parent gifts $10,000 from a bank account in the US. They are not themselves a UK taxpayer in any way, shape or form. then that gift is received by the person in the UK without UK tax or reporting obligations, and insofar as those assets are not cash but appreciated assets, maybe some gift of stock or other securities, the assets are received at their open market value for capital gains tax purposes. We're going to come on to those appreciated assets later because that's where one of the pitfalls can arise. What you can see there is it's very, very efficient for an American parent to give wealth to a UK person because the UK person pays no additional tax in the UK on receipt of the gift. The American parent may pay whatever tax is due when they make the gift, but certainly from the UK perspective, there's no need to make it any more complicated than that. That's assuming that what we've got is a direct gift from funds in the parent's account to a direct gift to the child. It can get more complicated where it is not a question simply of a account-to-account transfer. For example, if the parent wishes to make a gift not outright to the child, but into trust, maybe they're funding a trust in the US for the child in the UK, maybe it's what the Americans would refer to as a completed gift trust. The parents want to put assets outside the scope of US estate tax, then that is not a gift directly to the child in the UK, and we cannot guarantee there are no UK tax consequences. In fact, and it's an entirely different area, there can be a lot of tax consequences when someone in the UK receives a distribution from a foreign trust. Similarly, if the gift to the UK person came from assets that have not sort of sat in the parent's name forever, but at one point in the past were actually held through a different form of structure, then the UK might engage a number of anti-avoidance rules to say the gift from the parent isn't actually a gift from the parent for UK purposes, but it's a gift from a foreign trust, and the money from the trust merely came via the parent as a conduit to end up with the person in the UK. And the person in the UK can be taxed as if they had received a distribution from that foreign trust in the first place, thus engaging those same tax rules I mentioned previously. That we refer to in the UK as the conduit rule. And if the money in the parent's account has in any of the previous 3 years prior to the gift to the child been money that was in a trust, and what a trust is quite sort of a specific term here. I'm not going to go into it for the time being. But if that money in the previous 3 years was in a trust, then that receipt of the wealth by the child in the UK could be taxed as if it was a trust distribution, a foreign trust distribution. So parents in the US need to think carefully about the source of those funds before they make that gift. The final point I wanted to make on this question is the way in which the US and the UK treat gifts of appreciated assets differently. My understanding is that when that gift is made by the parent, the child in the UK does not receive the asset at its open market value, but they receive the asset at the donor's basis. In other words, if they then later turned around and sold the asset shortly afterwards, they'd pay tax on any gain during their own ownership, but also the tax on the gain that would have applied during the previous owner's period of ownership as well. That is different to the way in which the UK taxes unrealized gains on the gifts of assets, because in the UK, a gift is a disposal for capital gains purposes, and so the donor pays capital gains tax, and the recipient acquires the asset at open market value. Now, in the scenario I mentioned here, let's assume we have a US resident parent looking to make a gift of a UK property, UK real estate, to a UK resident child. We have a potential for a very significant tax mismatch. The US parent makes a gift of that property to the child, does not pay any US income tax on the unrealized gain in that property. The UK child receives the asset at the donor's basis for US income tax purposes, and the UK assumes that tax has already been paid, and therefore the child for UK capital gains tax purposes gets what the Americans refer to as a step up in basis. If the child then turns around and sells that asset the next day, they will pay tax in the US based on the donor's basis, even though it's UK real estate. And so you can end up with a surprising sting in the tail where the child in the UK has to pay US tax on that asset that was previously gifted. There are a number of other opportunities for double taxation in this scenario. There are actually some ways in which we can avoid anyone paying tax in either country on the unrealized gains. So if someone is looking at, for example, some US stock that is sitting at a very low basis, I'd encourage you to reach out to me, because it might be that you have a scenario where we can avoid the unrealized gains being taxed at all in either country. But that would be a discussion for us to have offline. But thank you for that question. It's a very, very common question we get asked. It's one which comes up increasingly frequently because of parents looking to carry out their own estate planning. And again, we would strongly encourage people to get in touch before the gifts are made so that we can best help them do the gift tax efficiently. The next question is one of my favorite questions. My parents are redoing their US estate planning. Does the fact that I'm UK resident mean they need to think differently about what that planning does? This covers some topics that we've discussed previously on this episode, and so I'm only going to cover those bits very lightly because listeners can go back and listen to my previous comments. Fundamentally speaking, what we are concerned about with a foreign estate plan is, will the UK treat the beneficiary in the UK as inheriting from a parent, or will they treat them as inheriting via an alternative structure like a trust, for example? So if the US parent is just leaving a will, and under that will they leave an outright share of the residuary estate to a child in the UK, then that is dealt with in a very tax-efficient manner, very similarly to the gift rules I mentioned in a previous question, albeit that in this scenario, the child is very likely to receive a step-up in basis in both countries on any unrealized gains in assets at the parent's death. That is a very simple scenario and is a very tax-efficient scenario. Where I see this question coming up more frequently, though, is in relation to parents putting in place trust planning as part of their estate planning, either because they're holding wealth through a revocable living trust or because they are putting in place irrevocable trusts for the benefit of the next generation. And in both circumstances, we can't just assume that the UK is going to reciprocate however the US taxes those structures. So what I would usually recommend that clients do is introduce me to the parents or introduce Collyer Bristow to the parents to have a discussion about what that US estate planning might do so as to encourage some tax efficiency and hopefully some flexibility into the estate plan, allowing and accommodating for the fact that at least one of the next generation lives in the UK. Sometimes I have everything I could want and I manage to persuade the attorneys in the US that maybe we can get away with a US will. Is the need for a living trust, is the need to avoid probate so severe in that state that we need to go through the rigmarole of rejigging the estate plan in the US just to cater for the child in the UK? Sometimes I get met very bluntly with the answer, no, we need a living trust. It's how we do things in the US, and the estate planning consequences and the probate consequences in the US, if we don't use one, are not worth thinking about. And then the answer is, okay, we need to factor in the best way of carrying out this estate planning and it's being received in the UK within the confines of the game that has been set, i.e. we have to play with the living trust that we've been given. And I've talked previously on this podcast to a number of guests and been on other podcasts we've rehosted on this series where I've talked all about why we need to think carefully about the ways in which the UK treats living trusts. But fundamentally speaking, at a conceptual level, what the parent in the US and the child in the UK need to think about is the reason behind the form of the US estate planning sufficiently impactful to override what can be very, very real risks of unexpected additional UK taxation when that child comes to inherit in the UK? If there is a risk of adverse UK taxation, then I would prefer there be as much flexibility in the US estate plan as possible so that the child in the UK, acting with careful instructions, can receive or not receive their inheritance at a time which best suits them, rather than receiving their inheritance mandated at a particular time, because it might be either that's a bad time for UK tax to arise because of the beneficiary's personal circumstances, or because the way in which the money comes out isn't actually that tax efficient, and it would have been more efficient if the ongoing trustees, for example, had had flexibility to make that distribution in a different way. So what I like to do is to get in front of the estate plan, sit down, maybe with the parents in the US, maybe with their advisors, maybe with the child in the UK, to say, look, here are the potential risks involved in this estate plan. If we kick the tires on it, how much UK tax is actually likely to arise? Sometimes the answer is not that much, or not that much because there's enough flexibility in this plan. Sometimes the answer is, if you carry on with what you're doing, there's going to be a potential for 35, 40, 45% UK tax in the UK when that beneficiary comes to inherit. And when you think about the fact that in the US, That money may well have been taxed during the grantor's lifetime. As I've had it posed to me sometimes, what right does the UK have to tax money that has never touched the UK before? They do have the right, because that's the way the UK tax rules work when someone receives a distribution from a foreign trust, for example. I understand that issue, though, and I understand that sentiment. And so the answer is, let's not leave ourselves in that position. So I'd encourage anyone who's in this position, either as the parent in the US or the child in the UK, and if they find themselves in the circumstances I've described, I'd encourage them to go and listen to the episode I did with Reshma Shah of Dwayne Morris in New York a couple of years ago, where we looked exactly at this topic, i.e. what sort of estate plans work where there are UK beneficiaries involved. So yes, definitely go and look at that episode. My next question concerns something slightly closer to home, and it reads as follows. My spouse and I are looking to purchase a new home in the UK. I'm an American, but he's not. Is there anything concerning the ownership of our home that we should consider? Now, this is a scenario that probably features a lot more Americans in the UK than they realise, because one of the most common features of middle-class life in the UK is owning your own home. And if you are a wealthy, successful person, that probably represents a core goal to your financial position. And because lots of people like to be in loving relationships and like to have security and peace of mind over their wealth, of course they're going to buy a property in joint names. That's a very common thing to do. However, where an American owns UK real estate, and particularly where that real estate is the American's main home, there are a couple of different really important tax pitfalls that we need to consider from an estate planning perspective. Fundamentally speaking, the UK has for a very long time been generous with capital gains made on the sale of a main residence. When you sell a house in the UK, if that property is your main residence, then you get what's called Principal Private Residence Relief, or PPR. Sometimes known as the main residence exemption. And basically it relieves all capital gains tax on the unrealized capital gains on the disposal of a UK property, be it a sale or a gift. It's a very, very blanket and popular tax relief. In the US, I've understood that that is not a blanket relief that the IRS offers. An American owning a main home can get an allowance, but that allowance is capped, I believe, and has been capped for some time, at $250,000. And you can also only exercise that exemption once every so often. And so what can happen as an American living in the UK is if your share of a property exceeds, or rather, if the gain on your share of the property exceeds $250,000, you might unexpectedly be in a scenario where the IRS is going to expect you to pay US income tax on the sale of your main home, where the UK, being where the property is located, provides a blanket exemption. Now, unfortunately, there is nothing in UK law or in the double tax treaty that we have with the US that alleviates the US's right of taxation there. And so this is a conundrum that a lot of Americans find themselves faced with. There are some solutions that are available, and one of the very common ones that exists concerns Americans who are in relationships, and when I say in a relationship with, I usually mean and married or in a civil partnership with a non-American. So an American citizen married to a non-American citizen, maybe a Brit, a UK citizen, for example. In that scenario, if the UK person owns some or all of the property, then US tax shouldn't arise because the non-American is not an American taxpayer. Now, if the American owns that property already, they could think about giving some of that property to the UK husband in this scenario. Maybe the American wife wants to make a gift. I believe for US gift tax purposes, an American can give wealth to a non-resident alien spouse, like a non-American spouse, and it's about $190,000 a year to that spouse. And so what you can do is you can divide up the property into into sort of tranches, into sort of chunks, and you can transfer, a chunk over time to the UK spouse, such that after enough sort of $190,000 worth of property has been transferred over, the UK husband ends up with either all of the property or at least enough of the property so that the residual share owned by the American wife doesn't carry a $250,000 gain. Alternatively, if you're looking to sell the asset in the near future, you could just use some of your lifetime allowance and transfer the entire lot over to the UK husband. Now, there are other things to say about that transfer process, particularly where there is borrowing over the property, but it does represent a very common estate planning problem that faces a lot of Americans, and probably the singularly most common gripe that American taxpayers have when they don't realize tax should have arisen, because they see it as UK real estate, and thus why is the American tax authority trying to subject it to tax. We can certainly help provide the UK tax advice on that transfer, and we can certainly help draft the relevant documents to put the relevant tranche or tranches into the name of the non-American spouse, if that's something that clients want to do. The other part of this that's very important, and which I want to stress, is what I am talking about in these circumstances is tax planning, is trying to achieve a favorable tax outcome. I'm not suggesting that it is necessarily good from a matrimonial perspective to dilute your share of the main residence, particularly if that's, the main asset in the family's name. There may be perfectly good reasons why one party does not want to transfer more of the wealth over to their spouse, or even all of the property over to their spouse. And so those individuals should take advice accordingly on the potential wider consequences of depriving themselves of those assets. But in a healthy, long-term, loving relationship where assets are shared anyway, this might represent a very valuable tool for avoiding what can be otherwise a very nasty tax in the future. My next question concerns powers of attorney, and it's a very straightforward question. Should I make powers of attorney in both countries? This is often coupled with a discussion about will planning, and very frequently I'll have already discussed with clients my concerns or preferences around having one will or two, and I addressed that earlier in this episode. From the perspective of a power of attorney, the situation is quite different, because unlike wills that are generally what we call portable between jurisdictions, you can use a will in one country to cover assets in another, powers of attorney are not portable, which means that as a general rule, if you need a power of attorney to be recognized in the US, you need a US power of attorney, and vice versa in the UK. So in the UK, our power of attorney regime is known as the lasting power of attorney regime. We can make powers of attorney, LPAs, for financial affairs and for health and welfare affairs. Financial affairs would cover things like, in the UK, you can make LPAs for financial decisions, and you can make LPAs for health and welfare decisions. Financial decisions would be things like opening bank accounts, taking money out of bank accounts, paying bills, all of those day-to-day expenses that can come up. But it can also include things like selling the family home if necessary to pay for care. Conversely, a healthcare power of attorney, a health and welfare power of attorney, covers decisions relating to the donor's health. So everything from day-to-day medication, what clothes they wear, right up to incredibly serious topics like end-of-life care and whether to sustain it or not. So those two regimes are entirely separate. One can make a financial power of attorney and a healthcare power of attorney. One can make both. One can make neither. I would not recommend neither. There is a similar regime in the US. Financial powers of attorney in the US are referred to as durable powers of attorney, and a healthcare power of attorney is referred to commonly as either a healthcare proxy or a medical directive. Now, my comments to clients is there is no substitute for having powers of attorney in all countries of all colours and stripes. So a UK healthcare lasting power of attorney, a UK finance lasting power of attorney, a US durable power of attorney, and a US medical directive healthcare proxy. Some clients want to take a more pragmatic view and say, I'm largely in agreement with my partner, with my family on end-of-life decisions, on healthcare decisions. Is a healthcare document necessary? Well, if you're not going to spend that much time in the US, then I've always assumed that the need for a power of attorney for healthcare decisions in the US is less, and vice versa in the UK. If you're not going to end up in long-term care or in a hospital in the UK, a healthcare power of attorney is going to have diminishing value. However, for financial powers of attorney, anyone with material wealth in both countries should think very, very seriously about putting in place a durable power of attorney in the US and a finance lasting power of attorney in the UK. The way I kind of scope it for clients is I say, if you feel incapacitated, are there aspects to your family's financial support that rely solely on your wealth? So is the mortgage coming out of an account in your name? Are direct debits for utility bills coming out of your name? If so, those are definitely accounts over which there at least needs to be power of attorney in the relevant jurisdiction. Maybe it might make sense to make that a joint account at the very least, so that if one party falls incapacitated, the other party can still access the account. As to whether to make a power of attorney in, for example, the US, if you have, a brokerage account in the US, clearly the answer in a perfect world is going to be yes, you should. But I'm aware that is a cost and an effort that has to be gone through, and everyone will have different opinions over that. The question I would pose is, if that account got frozen and it could not be accessed until the incapacitated party died, how problematic would that be to the family? And if the answer is that would be really, really quite problematic, and it wouldn't be a good idea to leave the account there, then a power of attorney should definitely be made in that country to make sure that access can be granted. The reason why powers of attorney are so important is because not having a power of attorney would mean that the incapacitated person's next of kin, their family, would have to otherwise apply to court to be appointed in that same role. And that is a much costlier and longer and fraught process. In the UK, we would refer to that as a deputyship process, where a deputy would be appointed. And in the US, I believe they would refer to that as a conservatorship process to appoint a conservator. It would not be my recommendation that any client actively and intentionally goes through the deputyship process compared to the otherwise relatively simple and low-cost effort of putting in place a power of attorney. So, ideal scenario, definitely put them in place in both countries. If clients are looking to save costs and they only ever sit in one country, maybe you can forego the healthcare power of attorney in one country, but that is really no substitute for having a thorough review of your circumstances and taking proper legal advice on what would be best for you. The last question today doesn't concern the law or taxes, but actually concerns the selection of advisors. And it reads as such: I know I need advice, but I don't know who to ask. Do I need a lawyer? Do I need an accountant? Do I need a financial advisor? This is actually a surprisingly common question, and it's one for which I actually think that the industry needs to be slightly clearer on, because we as a community sometimes don't make it exactly clear what roles we do and therefore what each person's specialism is. I should say first and foremost, being a lawyer is a fairly self-explanatory term. Most people know what a lawyer is. It's a catch-all term, but it tends not to be the stumbling block here. I've used the phrase accountant here. I know many of the accountant listeners into this podcast will be tearing their hair out at this point that I should refer to you as a tax advisor, because you don't review and prepare accounts. You advise on tax and do tax compliance. I do acknowledge that we should call you tax advisors, but the world knows you as accountants, so I'm going to use the phrase accountants here. Similarly, with financial advisors, it's a big umbrella term, and sometimes what we actually mean are wealth managers, sometimes we mean brokers, sometimes we do genuinely mean financial advisors. And I have a episode with Martin Heel and Jeanette Saxer of Schroders Wealth Management, looking exactly at the question of how I select a financial advisor. And my first question to them was, what do all these different terms mean? But let's just use the phrase lawyer, accountant, and financial advisor for the time being. The most important thing to say is, provided you are speaking to the right people, it doesn't matter which one you contact first. Certainly, I get great pleasure in receiving an inquiry that actually it turns out isn't for me and it's better served by one of the other two professions. And I'm delighted to be able to refer someone on to a valued colleague at another firm who I know will be able to deal with that question in a much more detailed and helpful sense than I'll be able to. And so in that respect, one of the nice things about the US-UK community, and lots of these people have been on my podcast, so I can attest personally to how generous they are with their time, is that we like to collaborate with each other and we like to share clients and stories and circumstances. And so if you are plugged into this US-UK professional advisory network, an advantage is that you are also getting, a node into the sort of the wider US-UK network. And, once you're on board with one of them, hopefully the other people will then follow in behind. However, if what you are looking for is a general understanding as to what they do, I would use this as a guiding principle, largely because it's the guiding principle I use. Financial advisors are the ones to give financial advice. I know that sounds flippant and obvious, but that means things like investment advice, decisions about where to put money, what to invest in, how you should save, into what accounts you should save, into what accounts or from what accounts you draw down from first, financial modeling as to what you need to live on in the future, how much money should you set aside now for your children, should you be invested in product A versus B, index fund A versus ETF B, all of these questions of a financial nature, they are ones that a financial advisor would look at. The tax advisory, the accountancy profession, wear a number of different hats. First and foremost, they will prepare tax returns. Most tax returns are prepared by the tax advisors, by the accountants, particularly things like your self-assessment tax return in the UK and your US tax return. Lots of Americans in the UK use dual qualified US-UK accountants. And again, lots of them have been very kindly on this show as guests. And a lot of accountants, tax advisors, will do tax advisory services. So will, rather than just do what they sometimes refer to as compliance work, they will actually advise on tax in an abstract sense. So, you come to them with questions and you receive tax advice. That is where the overlap can often be with lawyers, because we as lawyers also give tax advice. We are advising on the law and tax laws in particular, but there is a healthy overlap between the sorts of work that we advise on and the sorts of work that tax advisors will advise on. Where we do work that the accountants don't is in drafting legal documents and generally in giving legal advice. So, for example, estate planning tends to fall under the domain of lawyers because it involves drafting wills and trusts, powers of attorney, and those things. Those are legal documents, and so we as lawyers do those. And lots of the consequential tax discussions that arise out of those documents, like inheritance tax, for example, flow to the lawyers because necessarily they are a part of the estate planning. Whereas, for example, lots of the nitty-gritty about income tax, particularly things like employment taxation or pension taxation, tend to sit more with the accountancy community because it necessarily forms part of their compliance exercise with you at the end of each year. But there is a large overlap between what we can all do, and certainly where you have one of each of them in a discussion together, you're getting the best of advice. I should also repeat what I said previously, that in a US-UK context, it's very, very important to have people involved who are familiar with the rules in both countries. Now, for the financial advisory community and the tax advisory community, it is possible to get dual US-UK qualified people who can advise you on the consequences and the planning in both countries. The legal profession is a little behind in this, and you don't tend to find dual qualified lawyers with the same prevalence that you do tax advisors and financial advisors. But for the few firms that do have advisors in both countries or, under one roof, and there are some very lovely of those lawyers out there, a lot of lawyers end up in the position that we have been here at Collyer Bristow, and I am on this podcast, which is specialism in one country, qualified in one country, but with a healthy understanding of the way that tax works in another country, just because of the prevalence of clients that come from there or have those exposures. So in a US-UK context, you would ideally, I think, want a US-UK tax advisor, a US-UK financial advisor, and either a UK lawyer familiar with the US rules, or maybe even a US and separately a US lawyer as well. That would be, I think, the full roster you might need. If anyone wants to write in and say that I've left them out of that roster, I do apologize. I'd love to engage with you, and you can tell me who I've missed out. Thank you for joining us today on the US-UK Tax Talk podcast, and thank you for tuning into our very first Q&A session. I hope it's the first of many. As I mentioned at the beginning of the podcast, if you have any questions you'd like us to address in a future episode, then please contact us using the details in the show notes with this episode, and we'd love to hear from you. A reminder that we're releasing episodes on a monthly schedule on the first Wednesday of each month, so make sure that you like and subscribe so you don't miss an episode. In particular, if you can review this episode or like it on your streaming platform, it also helps the algorithm gods know who to send the podcast to next, so we'd please be very grateful if you do that. Check out Collyer Bristow's YouTube page, where you can see us now in our finery in our new studio, and we'd love to have you over there as well. Otherwise, thanks for watching.